we know that the U.S. Supreme Court came out with some huge rulings involving guns, the federal bureaucracy, federal authority, all sorts of things in the last few weeks. And I told you I would cover this and continue to drill down so you really understand how it matters and why it matters to your rights in the context of the Second Amendment fight and making sure we protect all of our liberties. And remember, I've also explained to you that sometimes it's important for we in the Second Amendment movement to appreciate and understand that cases that don't specifically touch on the right to keep and bear arms can also be extremely important to our Second Amendment rights, even though it's not obvious. I'm going to talk about a perfect example of this dealing with civil fines that the federal government has been levying on gun owners and why these are likely going to go bye-bye when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 attacks by Hamas on Israel teach Americans about the right to bear arms. A terrible, terrible lesson that the Israelis learned, but they never should have made that mistake. If they had only remembered what they were supposed to remember from the Holocaust and World War II, they would have understood the importance of armed citizens in anticipation of evil people trying to do evil things to you. They forgot that lesson, unfortunately. 10/7 was the result, and I talk all about that, those mistakes, and what Israel's learned from that, and I do it in the context of explaining to you, Americans, about why we must work overtime to protect our armed citizens and our Second Amendment rights and the entire Constitution. Check out Israel Disarmed on Amazon if you have a few minutes. All right, folks, so we've covered a little bit the U.S. Supreme Court end of the term, a lot of big cases. And remember, I've explained to you that sometimes some of the biggest cases involving our right to keep and bear arms and our freedoms generally, because again, as a reminder, the Second Amendment is only one aspect of the constitutional structure that's designed to protect our individual freedom, our individual rights. And it's not just the right to keep and bear arms, although that's extremely important, of course. It's also the right to free speech, the right to practice a religion, the right to be free from various government general warrants, for example, the criminal process procedures, the burden of proof, not to mention the structural constitution that forces, the Senate to fight with the House, to fight with the courts, to fight with the presidency, and so on, all of which is designed to help protect our individual rights from a rapacious, potentially tyrannical government. So in light of that, I talked to you last week about this really important case involving part of the Bill of Rights, the Seventh Amendment. The Seventh Amendment. As you may recall, the Seventh Amendment talks about a right to a jury trial in certain civil cases. I'm not going to bore you with the details because it's not important for you in your daily life. But the Seventh Amendment, that's the number 7, the Seventh Amendment gives you a right to a jury trial in civil cases. And the reason why this is particularly important is because for many, many years, the federal government has been essentially, in various contexts, using federal employees that work for the agency that regulates a particular area of the law. And not only was that federal agency in the case of the Jarkesy case, and we're talking about the Jarkesy case here versus the SEC, not only was like the SEC or the federal government serving as the interpreter of the laws and then benefiting from the Chevron doctrine that says to the extent that the federal agency interprets the law in one way, you have to defer to them courts. They were also the prosecutor of you, and they got to serve as the judge and the jury because one of their employees for the SEC, working as an administrative law judge, had the ability to fine you and bankrupt you with financial penalties. So Mr. Jarkesy went to the federal system and said, this is BS. I'm entitled to a jury trial before the Securities and Exchange Commission or any aspect of the federal government can fine me for something they say I did. And the last thing they should be allowed to do is bring me in front of a government administrative law judge that works for the same agency that is prosecuting, going after me, and then determine who wins, because they're always going to rule for their buddies that they have lunch with. And, of course, they're also going to fine me, and I'm entitled to a jury trial under the Bill of Rights, specifically the Seventh Amendment. And the Supreme Court in Jarkesy says absolutely correct, that if the federal government is going to fine you, in most instances, they have to sue you in federal court, and the federal court, because they're no longer beholden to the Chevron doctrine, will interpret the law, determine whether or not you violate in the normal course, and if the government wants you to pay a bunch of money because you misbehaved, you violated the law, whatever it is, then under the Jarkesy case, they have to not only sue you, they have to try the case in front of a jury of your peers, and it's up to the jury to decide, did you do something wrong? And if you did something wrong, they get to decide the financial penalties. They're your damages, your assessments, whatever it is, they get to decide. It cannot be an administrative law judge that works for the federal government that gets to decide how much you have to pay when they're being prosecuted by their buddies down the hall in the same agency. That's the Jarkesy case. And you may say to yourself, okay, Mark, how does this matter to me, an American gun owner? Well, I have to give a hat tip to law professor Rob Leiter on this, a very smart guy, flagged this on X, and he pointed out that this Jarkesy decision, and I agree, likely blows up the FAA, the Federal Aviation Administration / the TSA's ability to impose civil penalties for individuals caught bringing firearms or weapons or anything into the security section of TSA. Now, as you know, as more and more people have been carrying weapons for self-defense, and more people are carrying guns on a daily basis all across the country in light of, for example, the Bruin decision, and the fact that after 2020, people are very concerned for their safety. Obviously, we now have learned robustly and over again that you are your own first responder because the government is simply not going to protect you. Either they don't want to protect you because they don't like your political allegiances, or they can't protect you because they're nowhere around, or there's not enough of them, or whatever it is, or their mayor told them to stand down. Whatever the reason is, you are your own first responder. Now, I bring this up because what's been happening is that people who have been caught trying to bring weapons, and of course, none of these people, as best I can tell, are actually trying to bring a gun onto a plane. These are inevitably a mistake, right? People have these weapons in their knapsack. They carry them in an everyday carry. And next thing you know, they're going through a metal detector somewhere and they get caught because they forgot they had a shotgun shell in their pocket, or a bullet, or a gun or something in their knapsack, and they forgot to unpack it. I've seen this happen over and over again. It happens thousands of times a year. And even though I'm saying you should try to avoid that, obviously, but it does happen because, people get stressed out in many instances when they travel and they forget things and they are distracted and they're worried about the dog sitter and the babysitter and the taxi taking them to the airport and the packing for the week-long trip or the honeymoon, or they're stressed out because they're dating someone, whatever the reason is. You can see how people can readily and inadvertently forget things in their backpack. It's not an excuse. It's just kind of the reality of living as a human. So if you take a look at this graphic that I'm displaying on the screen, take a look at all the different prohibited items that can be discovered at checkpoint sites and the fines that the TSA FAA is allowed to administer. Now, here's the kicker. Under the Jarkesy case, as best as I can tell, they're not going to be able to just fine you for this. They would arguably have to go to court, sue you to collect this money. They can't just willy-nilly do it because, well, they're fining you. It's a civil penalty. It certainly seems like the sort of thing that you would be entitled to a jury trial because, again, it's an administrative agency working for the federal government, and they're saying that, hey, guess what? We're going to fine you this amount of money. We have discretion. And you're going to be like, no, that's not true. I want a jury trial under the Jarkesy case and the 7th Amendment. So let's take a look here. So let's take a look at just a couple of examples of the fine ranges. And I'll put a link to this site of the Federal Aviation Administration. Take a look at this. So if you bring an axe or hatchet or bow or arrow, ice pick, a knife with a blade, whatever these things are, you could be fined between $390 and $2,250 if you're found with a BB or pellet gun or a flare or something like this, or a realistic replica of a gun, right? A realistic replica of a firearm, right? A model firearm that you pick up at a gun show somewhere, you could be fined between $390 and $2,250. If you're actually caught with a unloaded firearm, that could be between $740 to upwards of almost $1,500. And if it's a loaded gun, apparently, they can fine you between $1,500 and $5,370. And all of this, in many instances, can refer to a criminal referral. Now, again, I'm not saying you should do any of this, and we don't want people to do any of this and bring meat cleavers and whatnot onto the plane. But the point is, here's an example where I'm sure that the FAA and the TSA, find some bumbling guy that screwed up and tried to bring something onto the plane. It wasn't supposed to be there. And next thing you know, they're going to fine this guy, and he doesn't have the ability to say, look, I wasn't trying to do anything. I'm a moron. I took sleeping pills. I'm going to take a long, a flight from New York to California. I took some sleeping pills like my doctor recommended so I can sleep on the plane. That caused me to have some memory loss. And next thing you know, I'm exhausted because I stayed up till 4 in the morning packing. I had to catch my taxi at 6 in the morning for an 8 a.m. flight, and I forgot the stupid thing in my backpack. My bad. I'm sorry. I screwed up, but you can't just fine me for that because, you can get to play this game because I didn't have any intent to do this. I simply screwed up, which happens every day all across America. No harm, no foul. And again, as we've talked about this before, this is a classic example of a malum prohibitum problem, which is it's something wrong just because we say so. There's no evil inherent in this. It's not like malum in se crimes or malum in se infractions of law, murder, rape, robbery, fraud, theft, things that are just inherently wrong. We know they're wrong, even in a state of nature. That's what malum in se is. These are all malum prohibitum crimes or violations, which means there's no evil intent or nothing uniquely inherently evil in this. Nevertheless, they get to fine you. And I suspect in light of the Jarkesy decision, it's quite likely these fines against gun owners administered by the federal government may go bye-bye unless they sue you and try to get that remedy in court in front of a jury. And my guess is no federal agency is going to sue you in court and go through a 2-year litigation to get a jury trial to fine you a couple grand. So as a practical matter, these fines may go bye-bye. Only time will tell. We'll see what the government has to say. They're pretty good about expanding their power and playing games. But again, as Professor Leiter indicated on X, it looks like this is a pretty good area right for gun owners to be able to knock out a major aspect of federal gun control law. And we'll keep you apprised as this story develops. But again, this is the kind of thing we should be on the lookout for, ways to take advantage of these non-Second Amendment wins in the Supreme Court to advance the cause of human and individual freedom. So there you have it, folks. Hope you learned something here today about the FAA, the TSA, and what the Jarkesy case may mean for gun owners when they come into contact with those agencies. Don't forget to subscribe to me on X at Furbox's Diner. Make sure you follow me and subscribe here on YouTube and beyond. And again, we'll see you again soon here at the Furbox's Diner.
Orders up. Table 2A.